2 and 3.
May I please look?
Why is it come up for?
It is for admission, my lord, today.
Yes, I understand.
The facts of the case is that, my lord.
It is again interim compensation.
My lord.
Interim compensation.
My lord, right after receiving the demand notice, my lord.
Just a minute. Just a minute. See the prayer portion. I'm seeing your prayer portion. Just a minute. Against order dated 26/9, right?
26/9/2023
itself, right? Long time. So let us
Subsequently,
see.
it was filed, my lord. There was some condonation of delay, my lord.
Okay. Can we
disposing of that condonation of delay, my lord? It took some time. Thereafter, my lord, it was admitted, and it is not admitted. No, it was listed, my lord.
listed? Where is the impugned order? Can we see?
If you not, your lordship will find
Page.
from page 32, my lord.
Okay.
The lordship has taken up 396, my lord. There are two cases, my lord.
Yes. I am taken up. Yes, 396. Correct?
Correct.
32 onwards. Okay, this is the order. I've seen the order. So the learned magistrate looked at the provisions and then he said that he recorded some prima facie satisfaction. And then he proceeded to give 20% to you, right? 20% of the check was, what is the absolute amount?
Check amount is 20 lakhs, man.
20 lakhs. So that will be quite an amount, right? 4 lakhs.
4 lakhs.
4 lakhs. So you make your submissions. Let's see.
The facts of the case is, my lord. Right after receiving the demand notice, my lord, I have filed a reply to the demand notice stating clearly that this check is not mine. And the account that from which this check has been given, my lord, that account is also not mine, my lord. I have completely denied that the stake for which you are demanding me money, my lord, that check is not mine. Account is also not mine.
Signature is also denied.
Signature is also I have contested, my lord. That the signature is also not mine. I have also on the same date, my lord.
But that's, as you know, that is once a signature is admitted.
I have not admitted.
The presumption starts,
My lord.
and then you have to rebut. But so I'll come to that.
I have also filed an FIR. An Indian FIR, my lord.
I'll see your documents. Just a minute. I will see your documents. Okay. And what is the second matter about? Second
matter is also another check, my lord.
Another check.
16 lakhs, man.
That's also 20%.
That's also 20%.
3 lakh 20, 7 lakhs 20,000. See, these provisions have been incorporated out of compulsion. That because, check bouncing matters, people have to run helter-skelter despite giving checks, whatever, in genuine cases. And therefore, these are anyway, but they have to be applied as per the guided, as per the discretion, wise judicial discretion, following the principles. And yeah, which document should I see next? You can make your submissions.
Come to Annexure 3, from page 27.
So 3, page 27. Yes. Yes.
This is my reply, my lord. There was an agreement
Hmm.
with the, my lord, complainant, my lord,
Hmm.
to sell his plot of land with
Hmm.
me, my lord,
Hmm.
which I have clearly, my lord,
You were planning to buy the,
not my lord, not me, my lord.
not me, not
He
you.
has sold this plot of land to someone else, my lord, and there has already been executed. Knowledge sale deed has been completed, my lord.
Can we read this notice?
Yes, my
Just
lord.
I can go through also.
I will start from para 1, my lord.
Yes, yes, start from there.
That on 12/9/2018, your client Pranab Jyoti Deka, in the capacity of a lawful attorney of his mother, Swarna Prabha Deka, has executed a land sale agreement with my client for selling a plot of land measuring 2 kotha, covered by so and so, situated at so and so, my lord, after taking an advance amount consideration of rupees 5 lakhs. Later, the said land sale agreement was cancelled by both the parties, and your client, Sri Pranab Jyoti Rekha, has sold the aforesaid plot of land partly to Dr. Suman Acharya and Dr. Krishna Talukdar for a consideration of 15 lakhs, and partly to Sri Hare Krishna Das for a consideration of rupees 9 lakh by executing registered sale of deed in their favor at the office of the senior sub register, Kamrup. So that plot of land was already sold off, my lord. And the agreement to sell that plot of land, which was with me, my lord, that was also cancelled, my lord. And he has sold
Duly cancelled.
duly cancelled, my lord. And
Thereafter, it was sold to someone
sold
else.
to, my lord, 3 persons for in part, my lord. And he has already executed sale deed in their favor, my lord.
The owner of the land was Pranav Jyoti Deka.
Pranab Jyoti Rekha,
The petitioner herein is
Madhuram Rekha, my lord.
Madhuram Deka.
Para two,
And Pranav Jyoti Deka was the attorney of your mother. or what?
of
No.
his mother, my lord.
Of
The
his
land
mother.
belonged to his mother, my lord.
And Madhuram Deka is, who is he in this?
Madhuram Deka was the, my lord, he agreed to sell the plot of land and find buyer, my lord.
context?
Now, para 2, my lord, page 28, my lord. That my client Madhuram Deka has no dealing with your client Sri Pranab Jyoti Deka after the cancellation of the land sale agreement executed on 12/9/2018. There is no debt due to your client from my client, nor my client has entered into an agreement with you on 24/2014 as stated in your above mentioned legal services. As such, the question of issuing any check to him by my client does not arise. That after scrutiny of the legal notice dated 5/7/2021 and so issued by you along with a copy of the check enclosed therewith, my client is convinced that your client Pranab Jyoti Rekha has committed the offence of forgery by making false checks of South India Bank Limited dispute by duplicating the signature of my client in the said check, as my client has no account in the said South Indian Bank, my lord.
I see. You have no account there.
No, my lord. I do not even have an account in the same bank, my lord. I have also filed an FIR before the Hatigaon police station, my lord, after receiving the demand notice, my lord.
Is it there for us to see?
Yes, my lord. That is, my lord, Annexure 2, my lord, starting from page 23, my lord.
Madhuram Deka.
This was registered and the complainant is out on bail, my lord. In this, my lord, case, my lord. Sections, my lord, under 420 and 468, my lord.
So, as I understand, this person, this Pranab Jyoti Deka, right? This-
Sonajuri Deka is the complainant, my lord.
Hmm. He had, he was, he was a lawful attorney of his mother.
Mother.
So he entered into an agreement with
With-
you for
with-
sale of their land,
For sale of
Their
his
land.
mother's land.
mother's land,
Which
and which was cancelled. Subsequently, that agreement was cancelled.
he sold that land, my lord.
No, no,
Three
the,
person.
the agreement was,
And the
was
agreement
cancelled.
with me was cancelled, my lord.
Thereafter, he sold that land, his land, mother's land, to three different
Three
persons.
different persons, partly, my lord.
And then he sent you this legal notice
Yes, my lord.
saying that you had issued checks
My lord.
and that you owe him money,
My.
right? And your contention is that you never issued those checks and you do not even have a bank account in
I do not
Cloud
even have a bank account in the
And,
state bank, my.
and lost the FIR for that,
My lord.
right? This is your main case, right?
My lord.
So at this stage, you should not be burdened with a
I should
interim
not be-
competition.
I have, my lord, even with their knowledge, my lord,
Hmm.
when he already knew that I did not have an account in that bank, my lord. Even then, my lord, he proceeded with filing this, my lord, NI proceedings, my lord. Your lordship, if your lordship, take your lordship to section 138, my lord.
Yes, that's section.
Clearly, my lord, here, section 138, my lord.
Yeah, that is.
When a check drawn by a person on an account maintained by him
Hmm.
with a banker for payment of any
Hmm.
amount of money to another person from out of that account for the discharge in part or in whole or in part, my lord.
Hmm.
Here, my lord, specifically from an account which is maintained by me, my lord.
Hmm.
The check should belong to me, my lord.
Hmm.
If the check itself does not belong to me, my lord, no proceedings under 138 is maintainable, my lord. And during the,
For the other matter also, you filed another FIR,
my lord,
same.
my lord,
Identical fact.
same FIR. And
Two
during
layer-
the trial, my lord, even the bank manager has appeared
Hmm.
before the court, my lord, and he has recorded the statements, my lord,
Hmm.
that
Come to that. And the provision for interim compensation is 140,
143A, my lord.
143. Yes.
Here, my lord, your lordship will find, your
Yes,
lordship has taken up this,
Account number is not
Deposition,
related to,
yes, my lord,
not related to Madhuram Dega.
my lord. The account relates to, my lord, one, Bhaspati Das, my lord,
Not to Madhuram Dega.
but not to Modram Dev. And the account is at dormant stage. The account number is not related at para 10. Account number is not related to accused.
I see. This was during the depositions.
Yes, he has deposed before the court, my lord.
Mhm.
In both the cases,
During the trial.
during the trial, my lord.
Okay.
And
Anyway, so
I had already submitted two judgments before your lordship, my lord, on the last date, my lord.
last date.
It should be part of the record, my lord.
Hmm.
One on section 143A, my lord. The considerations that the trial court should take into consideration, my lord, while awarding the,
This is Rakesh Ranjan. Shiva.
Rakesh Ranjan Srivastav, my lord, That is on 143A, my lord.
Mhm.
The last part, my lord, I rely on my lord, para 19, my lord.
It's prima facie evaluation and financial distress.
My lord.
Those things.
Also, my lord, merits of the case, my lord, it's a very, whereas in this case, my lord, even when I have appeared, my lord, I have stated, my lord, that this account do not belong to me, my lord. These checks are not mine, my lord.
Mm.
In that, my lord, condition, my lord, awarding, my lord, 20% compensation from me, my lord. I am not before your lordship for watching of the trial, my lord. I am willing to face the trial, my lord.
But with regard to the compensation.
I am only with regard to the compensation, my lord. If, my lord, after the trial is over and it is found that I have to pay the amount, I am willingly pay, my lord. But
No, the thing is that if you have never issued the check, then
My
as
lord.
per your contention.
in that regard also, I have submitted judgment, my lord. The Jugesh Sehgal versus Samsung Singh Gopi, my lord.
Another judgment, it's already submitted.
Yes, my lord, already submitted.
I have found this one. No, I found an old judgment. Ratan Sinha, this is a different thing. Rakesh Ranjan Srivastava, and what is the other judgment you mentioned?
There is Jugesh Sehgal versus Samsir Singh Gopi, my lord.
I think I was handling this file.
The lordship may take up with
No, it's okay. You can give me a spec of English if you have. Otherwise it will go from there.
In this case, my lord, the check did not belong to the accused person, my lord. And the Supreme Court has held, my lord, that no case is maintained, my lord. No case is maintainable, my lord. I am relying on para 22, my lord.
Para 22.
Para 22.
Yes. You want to read this?
My lord, I have
Oh,
given
you
a copy.
got it. I will take out. You've given it. So in this case, it was squashed.
It was password. Since this check and the account did not belong to the accused person, my lord, no cases under section 138 is maintainable, my lord.
Okay. This much only.
This much, my lord.
Oh.
May I please, my lord? My lord, may kindly take up section 143A for a moment, my lord.
Yes, I have seen it once. I'll take it up for you again.
My lord. This is a statutory provision, my lord. The learned court below have passed the order under this section, being empowered under this section.
There is no doubt about that. He's
Yes.
empowered. He's empowered
I-
and he has also recorded a prima facie satisfaction.
Yes.
But we are, as an revisional court, since he has taken the dispute to this court, we have to cross-check that, right?
My lord, while framing this provision, my lord, what was the intention of the legislature, my lord? Kindly see, my lord.
But one this thing that this any cross-examination was put with regard
No,
to this.
I'll satisfy your lordship too, with regard to that also. So, my lord, it says, power to direct interim compensation. Notwithstanding anything contained in the Code of Criminal Procedure, the court trying an offence under section 138 may order the drawer of the check to pay interim compensation to the complainant in a summary trial or a summons case where he pleads not guilty to the accusation made in the complaint. So here also he have pleaded not guilty. and in any other case upon framing of charge. The interim compensation under subsection 1 shall not exceed 20% of the amount of the check. That is also met. It is 20% only. This is also not violated. The interim compensation shall be paid within 60 days from the date of the order under subsection 1 or within such further period not exceeding 30 days as may be directed by the court on sufficient cause being shown by the drawer of the check. If the drawer of the check is acquitted, now my lord, this is important. The court shall direct the complainant to repay the drawer the amount of interim compensation with interest at the bank rate as published by the Reserve Bank of India, prevalent at the beginning of the relevant financial years within 60 days from the date of the order or within such period not exceeding 30 days as may be directed by the court on sufficient cause being shown by the complainant. Now, my lord, lordship will.
Yes, yes. The time frame is there,
Now, my
60
lord,
days plus 30 days.
yes.
Hmm.
Now, lordship may kindly come to
But
page 35.
Yes, but the section does not say how it says when it can be exercised,
No, my lord.
right? And
The protection. I am on the protection.
yeah, yes,
Protection
is there.
given to the complainant.
Yes, but no, well, in this particular case, was a indemnity bond or
No,
was
my
given?
kindly come to page 35 for that, my lord. Page 35
No,
for a moment.
I'm
This
not
is the impugn order and the last part of the impugn order. Page 35. Lordship have found page 35.
Yes, yes, undertaking on affidavit.
The complainant is also directed to file an undertaking on affidavit that he will return the compensation amount along with interest in case if the complainant fails to prove his case. Now, my lord, the legislature, while framing this law, this section, have well taken care of the fact that what if the complainant is acquitted or the accused is acquitted? So that has been taken care of.
No, the
First,
thing is that
now, my lord,
it's a debatable provision actually. It is not under challenge as a legislation, as a legislative provision. But the thing is that this, because as I said, no, this appellate amount of 20%, this has been done in the backdrop of bitter experience of complainants. But the thing is that in every case the accused will have this grievance that he is being prejudged. You know, that is the cause. Therefore, that prima facie satisfaction, whatever is necessary.
now, my lord, lordship,
And so since the statutory section, just bear me for a moment.
No.
The statutory section does not speak of any specific direction is there for indemnity bond. So therefore, the flexibility is there. So in this case, you were directed to give an undertaking on it,
yes, yes.
right? And you gave according. You
My-
gave the undertaking.
No, my lord, he has not yet paid.
No, no, no.
Only when I receive, I will give the undertaking.
Yes, of course. He has not paid. He's come up for challenge.
So that
So,
phase has
yeah.
not come.
The directed to he has to pay within this period,
Yes.
and thereafter you give an undertaking.
Yes.
This is the direction. Yes. Fine. Next.
Now, my lord, in an NIACT case, my lord, there has to be a legally enforceable debt.
Mhm. That is a foundational fact,
Yes.
right?
Now, my lord, there was a plot of land and the complainant and the accused have entered into an agreement. In that agreement, the complainant gave the land to the accused. And in the sale agreement, it is specifically mentioned that the accused, the petitioner herein, can bring prospective buyers. And the condition was that the accused has to pay rupees 60 lakhs to the complainant. And whatever above 60 lakhs he gets, it will be his accused profit. Now, my
He brings buyers.
yes,
The
if-
buyer buys for 90 lakhs. So
30
he
lakhs
gives
is
60
his-
lakhs, 30 lakhs.
his profit.
And-
Now, my lord, this is a registered agreement for sale. Subsequently, now it is their argument that that registered agreement for sale has been duly cancelled by another registered agreement for cancellation. So there is no legally enforceable debt. What happened in between, that is not submitted before the court. That is in the lower court record, my lord. What happened, my lord? As per agreement, he brought 3 buyers. The accused brought 3 buyers. I'll give the names. I'll take your lordship to that relevant portion also. He brought 3 buyers, my lord. Now, since I have an agreement for sale, registered agreement for sale in favor of the accused, I cannot execute sale deed in favor of these 3 buyers. So naturally, my lord, I have entered into a cancellation deed with the accused. That the agreement with him is cancelled. Now the 3 buyers brought by him, I have executed sale deed in favor of these 3 buyers. Kindly come to page number, my lord.
So the agreement was cancelled with regard with him.
Yes, definitely it has to be, my
And
lord.
you sold the amount, the land to these 3 people
This-
directly,
3 persons bought by him.
directly,
Directly, my lord.
directly.
Otherwise, my unnecessary, he has to pay tax.
And then what happened?
Then, my lord, kindly come to, my lord, page number 13. Page number 13. This is from the trial court records, my lord. Page number 13. Para 4. This is my complaint petition, my lord. Evidence is in the same line.
Hmm.
That on the strength of the said power of attorney, the complainant had undergone a registered agreement with the accused to sell the said land by document reference number so and so, dated so and so. As per the said agreement, the total sale proceed was fixed at rupees 60 lakhs between the complainant and the accused. In the said agreement, a provision was also made that if the accused, after execution of the said agreement, intends to sell the said land to some third party, then the complainant would be bound to execute sale deed in favor of the third party, if so instructed by the accused. Such provision was made in the said agreement so that the accused could sell the land at a much higher price than rupees 60 lakhs and could earn a good profit by way of brokerage. On the day of execution of the said agreement, the complainant handed over the possession of the said land to the accused. Para 5. That after execution of the said agreement dated 12/9/2018, the accused searched for third-party customers so that he could sell the said land in much higher price than rupees 60 lakhs and could earn huge profit. But the accused could not arrange any purchaser till 2 years from the date of execution of the said agreement dated 12/9/18. Then the complainant insisted the accused to cancel the agreement and to accept his advance money paid earlier. Then the accused requested the complainant to wait for few more months and stated that he has got customers and negotiation was going on with them. The accused had also placed an offer to the complainant that he would not adjust the advance money paid earlier with the total sale proceed of rupees 60 lakhs as promised to the complainant earlier, as it took a long time of 2 years to search for customers by the accused person. That means the accused agreed to the complainant to pay rupees 60 lakhs excluding the advance paid earlier in respect of the land under reference. Then the complainant agreed to the offer of the accused and extended time till November 2020. That accordingly the accused brought 3 customers, Dr. Suman Acharya, Dr. Krishna Talukdar and Hare Krishna Das. Accordingly, entire 2 katha land was conveyed to those customers as instructed by the accused as per the agreement, and the complainant had executed 2 registered sale deeds on 7/11/2020 through the process of commissioning in the house of the accused and instructed by the accused in favor of the said customers. The complainant was not aware at what price the accused has fixed the sale price of the land with the said customer. The complainant was assured by the accused that he would get his rupees 60 lakhs as promised by the accused earlier, no matter what amount the accused sells the land to the customer. The accused collected 2 checks from the purchaser for a total amount of rupees 24 lakhs and handed over to the complainant. And for the balance promised amount of rupees 36 lakhs, the accused issued 2 post-dated checks in favor of the complainant by check number so-and-so dated so-and-so for an amount of rupees 16 lakhs and check number so-and-so dated so-and-so for an amount of rupees 20 lakhs, both drawn at the dispute grounds of the South Indian Bank Limited. This is the actual story. Now, my lord, if we listen to their story, they have not brought these things. And as such, they are saying since there was an agreement for sale, that agreement for sale was cancelled, so there is no legally enforceable debt. But this is the actual story. The agreement for sale has to be mandatorily cancelled if I have to do a sale deed with some third person. So this is, now my lord, these are matters for trial, my lord.
True.
Now, lordship, I hope, Lordship, I
Yeah, yeah, I have
could
understood.
satisfy you on
Yeah,
this
yeah, yeah,
point.
but before, since this is there in this paragraph, so I just want, if this, you do not, this deposition, according to this deposition, this, one of the check was issued on this account number,
My lord,
061, so it is not related to accused Madhuram Deka.
Well, I am coming to that also, my
No, no,
lord.
yeah, because I want a,
Have I
this is my
satisfied
query.
your lordship on this point on the
No, no,
legally
it's
enforceable
not,
debt?
satisfaction will be at the time of,
My lord,
evaluation.
now lordship kindly come to this deposition.
Yes,
Lordship is taking up deposition for case, NI case number 59 or 58, lordship?
59.
59.
One, some, Somudrajit Gogoi,
Yes, my lord.
branch manager, South Indian Bank, Dispur branch.
For that, my lord. And lordship is taking up CRP 396.
Yes, yes, record has come, Scan record has come. So
Yeah,
you have
now-
given,
now
you've
Lordship
given
may
me a
kindly-
copy, I can see from here only.
Lordship, kindly come to page 21 for a moment of the CRP 396.
Page
21, my lord.
of your petition, of his petition.
Yes, his petition,
Acha.
CRP 396.
Yes, yes, yes.
Lordship will find a check there.
Yes, yes,
Kindly see, lordship, account number is not clear.
account number.
And if lordship matches this account number with the account number in the deposition, kindly see, lordship, how can we say that this is the same account? Again, this is a matter of trial.
062, you have it before you,
Now,
062,
these are not there, my.
605,
Yes, I have seen the lower court.
605,
There
three-
is not clear.
30001, this part is not clear.
So, my lord.
This part is, no, that's 18. What do you say with regard to
No,
this?
my lord.
My lord.
Photocopying is,
Because of the photocopy, my lord.
but what still,
But the bank manager, he has stated, my lord, he knows the account.
Let me satisfy.
He
your
has
lordship.
come with accounts, reports and all, but let him finish, my lord.
Now, my lord, kindly come.
no,
to
no,
the-
as he in the legal, because we are not, see, we are not into quashing. We are seeing whether because he's not been, we are not going to, we are, just don't confuse that. We are not into quashing jurisdiction.
My lord.
We are seeing whether the interim
get it.
compensation should have been paid or not.
Lordship may kindly take up the deposition now, my lord.
Let us see the legal notice, which was the statutory legal notice. Is it there? Legal notice, statutory legal notice. What is the check number? What is the check number?
In the legal notice, they have not mentioned the account number. In the FIR also, they have not mentioned the account number.
No, legal notice given by the complainant.
Yes, my lord. That is page number 2.
Because a person may have more than one account. This account is not related to Madhuram Deka.
I will satisfy lordship.
And when the check was issued on which account? We have to just first see. The check was issued
In the
on which
deposition-
two accounts?
In the deposition, the bank manager has stated that I do not have any account. That person does not have any account in this South India Bank. Not this account, man.
Where
Not
is it?
any account.
We
With
have
regard to
stated
that, my lord,
Yes, yes,
my
madam.
arguments
Where-
are still reserved, my lord. I'll make.
Just a minute. Where has it stated?
Page number 27 is the legal notice, my lord.
No, in the deposition, this account number is not related to
Yes.
Madhuram Das. But he has not stated that he does not have that. That could have been a question actually. That whether he has any account in South Indian Bank, Dispur branch. Anyway, please.
Legal notice, my lord.
At,
Page 27, my lord.
yeah, I am on that. Yes.
Yes.
This we had.
Kindly see, my lord.
Mhm.
The entire, my learned friend has already read the entire legal notice, my lord.
Mhm.
In the entire legal notice, there is no mention of any account number. They have also lodged an FIR. In the FIR also, they have not mentioned any account number. And my lord, in a case of dishonor check, my lord, this ROE is not expected to know the account number of the accused.
May not know.
Yes, my lord.
Hmm.
And this is the notice, my lord. There is no account number is mentioned.
Because we cannot go into disputed facts. at
Yes,
this stage.
my lord, we cannot.
See,
And-
one thing has to be appreciated that interim compensation at this stage, at a preliminary stage with at least to some extent it amounts to prejudging. That's why it's a disputed provision, though it has not been set aside by Supreme Court, is that it has its own justification. It is not a right to get to have interim compensation. There should not be disputed facts of such a nature that they require, without negotiating those disputed facts prima facie, you
My-
cannot grant.
My lord, there is.
You get my point? It's not a right.
My lord, may I kindly come to the deposition for a moment, my lord?
What are the records available? Let us be, let us not go into complications. Which was the, well, let us see the checks first. What is the check number and what is the bank of the two, giving rise to the two propositions? 396, which is the check? 396, which is the check? Have you annexed? Please, 21 is the check, right? You should have annexed a more legible copy,
Because that is the
You know-
photo copy they have given me, my lord, in the demand notice, my lord.
But
This is not my check, my lord. Lordship may understand.
that is your
clearly.
contention.
That is the photostat copy of the check that we have photostated, my lord.
Mhm.
Because he has not given me a clearly legible check, my lord. Let him produce the check. The check
You
is written-
denied a signature.
Yes, my lord, I have denied the signature, my lord. That is why I have lost the FIR, my lord. Because he has forged my signature in a check that is even not mine, my lord.
The check number is
Check number, my lord, here.
05045164, right? Dated 14/6/2021.
My lord, the account number can also be, my lord.
My lord, the deposition of the bank official may be taken into account. He have nowhere said that this check is not his.
The check will have to have an account. How will he pay the check?
No, my
account?
lord. On the strength of the deposition of the bank manager, he is saying that this is not his check. But the bank manager has not deposed that, my lord.
No, that is cannot depose also. And
What
actually,
he has said, my
is
lord.
that this account number does not belong to this accused.
He has also stated the check is of Bhaswati Das, my lord.
No, he has not, my lord. My lord, let us meticulously read the deposition, my lord. Kindly, my lord. Today
No,
I have appeared on
no,
this.
he has said this account number belongs to Bhaswati.
Yes. Who have asked him to bring Bhaswatis, my lord? That is there, my lord. Kindly, my lord, bear with me for a moment, my lord. Today I have appeared on receipt of someone along with documents. I am working as branch manager, South Indian Bank, Dispur branch since 2023.
Mm.
I have brought bank statement of account number so and so, of account name Bhaswati Das from period so and so to so and so. Exhibit P10 PW2 proved in origin. This is the bank statement, my lord. Is the statement of account number so and so of account name Bhaswati Das. Exhibit P1 PW2 is the check issued by our bank, my lord. This is as simple as that. Check issued by our bank. Whose check not stated. On 15/6/21, check number so and so was returned. That is also admitted that this check was returned. The statement does not reveal grounds of return. Obviously, my lord, it does not.
But
An electronic
this
message.
check is with regard to, that is why he brought this account details. Now, this check is related to this account. That's
No.
why he brought
Nowhere it is
prima
there.
facie.
Nowhere it is
This
there.
account number is not related. Now, let us see your statutory notice as complainant. I want to see your statutory notice, your notice. Notice that you make the demand notice, your demand notice. Let us see your demand notice. Unfortunately, this is not there, but your demand notice as
That
complainant.
will be part in.
Yes,
in
it
the
should be
record,
there.
my lord.
It should be in the record. Don't
And
worry.
also the account number can be verified from the record, my lord.
It will be here. Don't-
Record is already
don't
there,
worry.
my lord.
59, right? I think-
Exhibit 4, my lord.
Yes, yes. Just a minute. I will find it here. Don't worry. If we do not complete, we'll keep it part. So definitely, I mean, if the person is agreed, is awaiting payment of as much as lakhs of rupees, then he expects some payment. At the same time, this person, if suppose he has not, then obviously he'll also be totally against making any payment. So that is the issue we have to decide. These are order sheets actually, these are very relevant actually. Main thing is this documents.
Bank manager statement doesn't help him in any manner.
Let us see the demand notice. Where is the demand notice? Or your complaint petition, initial deposition. Yes,
Lordship,
this
we take
this may also help.
Lordship,
Initial,
I'll give
initial
my copy.
deposition of the complainant on it. This may also help.
I am giving my copy, my lord.
Yes, yes.
I have taken photographs. I'll just
Yes,
read
yes.
from these photos. Certified copy, lordship can.
Just a minute. Just a minute.
My.
The check which was dishonored according to your initial deposition is 045-164.
Yes, 045-164. And another check is also there.
And this is the same check which he has deposed.
Yes.
Manager has deposed with
Yes,
regard
my
to
lord.
the same check. That is
Same
why I wanted to check from the demand. Same check,
Same.
Same check, my lord.
same check.
This is the check he gave me, which is dishonored.
And he has not stated, but he has not stated, he should have stated whether this check is relatable to this account, but he has not stated. He has stated that this account does not belong to the accused.
What is it?
In para 6, para 5 of your initial deposition in the record. You just mark it so that for convenience later you also have. And the other one is 045-163.
Yeah.
163. There is a similar deposition with regard to the other
Yes,
matter
yes,
also.
that has already been submitted on the last date, my. I have already submitted.
The cost of repetition, I'm saying, no, these provisions for interim compensation has been made out of compulsion.
Yes.
Because the person, in genuine cases,
My lord.
a
it should
person
be
has
challenged.
lent money,
My
you
lord,
know, to help someone and he's running helter-skelter.
my lord.
And he's running after his own money.
My-
Due to these bitter experiences, these things have been incorporated. But it is our duty, all of us, councils, to apply it fairly.
My lord, that is my humble submission. Not in my lord,
But see,
every case is
no.
my lord.
That
it
is
has to be
your
awarded.
of course, I have to decide, that is your contention. But your good friend, he's not convinced. He says that, it's a genuine dispute. So that is the thing we have to decide.
And my lord,
My lord,
second time, one check, my lord, they say signature does not match.
Mm.
That means it is someone, if we presume that it is someone else account, so signature doesn't match. My lord, another check, my lord, it is returned for insufficient fund. If lordship take up criminal revision petition 394.
04545-163.
Yes.
That one, no? Other one?
Yes, yes, my lord.
045-163.
Criminal revision petition 394, page number 23. The bank says insufficient fund. Their bank says signature mismatch.
not my bank. That is my condition. It is not my bank, my.
Page, no, bank, no, how can bank?
We know.
Page 23.
Both of you are good learned counsels and you already know these things. We know these things that the presumption comes, once the signature. Otherwise, if it's disputed, then you'll have to probably take help of forensics
Yes,
right?
my lord. Page 23.
or some other evidence.
Page
Yes.
23 lord,
Of the petition.
of 394.
Yes.
Here,
Now,
394, page 23.
Please. Should I give it back to you or keep
No,
it?
lordship will take it.
You have a copy. But it's better to be, I'll check it from the record.
It is already in the record, my.
Should be in the record.
Because this was, my lord, on 19 April 2024.
We may not, because I am today, I am not,
Yes, yes.
because another petitioner in person, he's come from Kolkata.
My lord.
He argued his matter. The another one is there. I have assured him a few minutes, at least 15 minutes.
My lord.
So we'll close in 6 minutes.
5, 6.
And then we'll keep it. No, we'll keep it. If you want, we'll keep it
Okay.
further on Tuesday, Monday or Tuesday. We would have heard it in second half today. Since I'm not, I'll give you.
My lord.
We should have the satisfaction. We should submit concisely,
My lord.
but each council must have the satisfaction of making a submission. But these are all duty.
Very grateful, my lord.
No, it's okay. It's my duty. So we in our system today at this stage, we have to, make submissions concisely and we have to write concisely
Yeah.
to save time. So that the same time saved is available for other orders. So much payments is there. Anyway, so now I am on
Page
394.
23. Page
Yes.
23, my lord. The reason for return is funds insufficient.
Yeah, this check was returned like that, yes.
So, my lord, signature mismatch returned is something else. And funds insufficient is something else.
So that deposition also he has stated that funds are insufficient. He was returned due to insufficient.
My lord, if you go by their facts,
I get your point.
that this is not my account,
Hmm.
not my signature,
Hmm.
then here, my lord, bank admitted his signature, but returned it due to insufficient funds. That is what
That's
comes
your
up, my
point.
lord.
That is your point.
Yes, and my lord, on 2 points, my lord,
Mhm.
I'll just sum up, my lord, for today, my lord. If required, we will continue, my lord.
Hmm.
To sum up for today, my lord,
You sum up.
my lord.
We'll give one more day and finish it.
Yes, my lord. My first point, my lord. They are on the point that there is no legally enforceable debt. I have showed how there is a legally enforceable debt. That is before the court. Secondly, they are saying that this is not my account and the bank manager has confirmed it. Bank manager have done nothing, my lord. He has brought some Bhaswati Das account. Why he brought? There is no explanation that he brought it with regard to the check or what. He brought it, some Bhaswati Das, and entire deposition is on Bhaswati Das, my lord. And on the in the last line of the deposition, what he have stated that this is a check, lordship. I'll just take your lordship there again. Last part of the deposition. He says the present check may be issued to the account holder as instant checkbook. We cannot rely on his evidence. So there is a legally enforceable debt.
Maybe issued to the account holder as instant check.
Yes.
Why it was
Means-
it was answered because why there is no name.
Hmm.
In that query, my lord, he has answered because when account is open, my lord, and a person requires check, my lord, then instant checkbook is issued, my lord.
To the account holder.
In that
And-
instant, my lord, no name is there on the check, my lord. In that query, well, he has said, "No, not to, my lord."
In the chief, para 10, the account number so and so is not related to the accused Madhuram Deka. We are also not saying that. It may be of somebody else.
This copy of the check must be available here also. No?
Yes, my lord. It must
This
be
one, the
available.
other one,
Yes, sir.
054, that one. Where is it? Can you help me with that?
The lordship will find that.
This one. Both the impugn orders are identical, almost similar, same. Yes, this one, this one. Mhm.
Submission.
6-3, right. 6-3. Okay.
There is nothing on record, my lord, to show that the check was not issued from his account. Absolutely nothing on record, my lord. And as a Drohi, I am not expected to know his bank account also. He got every opportunity to cross-examine the bank manager. Why did he not cross-examine the bank manager whether this check is of any account related to the accused? He have not questioned.
The cross-examination is
He-
should be also
he
be
said-
there, my lord, but it is not with me. But it should be part of the record, my lord.
Let's
My
see.
cross-examination.
Anyway, we have some more time for this.
To sail through using Bhaswati Das.
Anyway, well, I'll see. Yeah. The heard Mr. Parasar, no?
Parasar.
Land Council for the issue, was agreed by the order dated ... passed by the learned JMFC,
JMFC.
Kamrup,
Not Samrup, my lord. This is Nalbari. my lord.
Nalbari, JMFC Nalbari. Nalbari. Impugn order dated 26/9/2023. Invoking section 143A of the NI Act, directing payment of interim compensation quantified at 20% of the check amount. Full stop. Also heard learned counsel,
F. Khan.
F. Khan Learned Counsel for the respond number 2/complainant, who contends that the learned trial court has rightfully exercised the said, invoked the said power to grant interim compensation. Stop. The scan record is available. Stop. However, arguments were not concluded. When should I fix it? You tell, let me know next
it,
week. Huh? Don't keep it next week. Thereafter will be last week. So don't keep it.
As per
Next
lordship-
week you can keep it. We can keep it. It will be fresh in my mind,
Yes,
in our mind.
As per lordship's confirmation.
On Tuesday. Huh?
Anything, madam.
Tuesday will be which day?
Nine.
9.
Can you
Nine.
Ninth, my lord, I have some difficulty, my lord. 10th, my lord, 10th or 11th, my lord.
11. Okay. 11.
11th. First day.
My lord, no.
11. Right. Yeah, 31. Matter may be kept as part of. Right?
Matter.
Mm.